So let's take a look at what the remedies are for a ADA lawsuit. So there are several remedies available. First and foremost, the issue that will be central to the case is injunctive relief. The plaintiff's going to sue because they can't get access to the building, or they've been discriminated in some way by the features of the building or perhaps website, if it's a website case. So they're going to be suing for injunctive relief, which is of course a court order to fix the property, remove the barriers, or update policies, perform some work to provide access. The next is under the ADA, a prevailing plaintiff can receive their reasonable attorney's fees and costs for filing the case. And so we'll frequently see motions for attorney's fees if a plaintiff prevails in the case, and they'll be asking for that money as well. In California, there is the Unruh Civil Rights Act, which largely mirrors the ADA, but it extends a bit further, and it provides statutory damages of $4,000 per visit, and that's a minimum. So this is not per barrier. That's what some people think initially. So it's not each specific barrier, like each ramp or doorway that they encounter that's out of compliance. It's really per visit. So you can think of it more as almost a per day type of damage. And so the cost of these cases really can jump up quite dramatically, because you've got the cost of injunctive relief to update the property, you've got plaintiff's attorney's fees, defendant's attorney's fees, and in some locations like California, statutory damages.
Now, those statutory damages not only apply to each visit, Stu, but don't they apply to deterrence damages? And can you explain that?
Yeah, plaintiffs have received deterrence damages. So these are damages that they receive for being deterred from visiting the property, wanting to visit, but feeling unable to because of the accessibility issues there.
One other thing, while the ADA doesn't specifically allow for prevailing defendants to recover attorney's fees, Stu has recently won 2 cases in federal court where we moved for, first of all, we advised the plaintiffs in the beginning of the case that there really wasn't any merit to their argument, and we had a lot of case authority to support it. But plaintiffs pushed on nevertheless. We filed a motion for summary judgment. On the eve of the motion for summary judgment hearing, the plaintiff dismissed the lawsuit. We then filed a motion in 2 cases for attorney's fees and costs, and we won because the court, citing a case that I had litigated many years ago, found that there was no merit to the case and it was frivolous, and awarded us 100% of our attorney's fees. And like Stu mentioned, defending a case through discovery and a motion practice is very expensive these days. But a prevailing defendant can recover attorney's fees and costs if the court finds the lawsuit was frivolous.